what evidence do the police need to charge you? So this question is almost based on a false premise, because the answer these days is that the police can't charge you apart from in the case of just one or two very minor offences, things like traffic offences, for example, minor traffic offences. The police used to have relatively broad powers to charge for offences up to a sort of medium level, but these days they don't. And that charging decision is actually now made by the Crown Prosecution Service in almost every case. Just to clarify, what charging actually means is when you get to the point where you've got the evidence that you believe might be required by a court to successfully convict someone, at that point you charge them, which means essentially a document is put together with all the evidence on it and the name of the person, and it's sent to the court, so it's then in the court system. The CPS, the Crown Prosecution Service, is essentially an organisation of lawyers who prosecute offences on behalf of the Crown, which is just United Kingdom speak for the state. And it's CPS lawyers who look at the evidence that's been gathered by the police about a particular person in a particular case, and they make that decision. Is it worth sending this to court? Do we think there is a realistic chance of conviction? Because what not everyone recognises is that the courts don't just get everything put in front of them, and that's simply for an economic reason. It costs an awful lot to run a case because of the salaries of the lawyers involved and the all the administrative staff and the buildings and everything. So you actually need to have quite a high threshold of evidence before the CPS will decide this is worth putting in front of the court.